I don't know under those lights whether I'm confessing to the Lindbergh baby kidnapping or anything else, but wow, it feels like I'm having my retina checked. Any event, this is, I think, first of all, let me thank everybody from INSA and FCA who have worked so hard to put this groundbreaking event on. We have done individually important symposia over the years, but most of those have been in classified settings for audiences of intelligence professionals. And I think getting out into the public square on an event like this is a huge part of what intelligence, American intelligence has to be credible. And that's the same thing we're going to be talking about today. I think if you went out on the street and asked people about should the government keep secrets, I think there would be an understanding that there are times the government must keep secrets. On the other hand, what about privacy? What about freedom of the press? Things of that sort. And I don't think it's a case of cognitive dissonance that Americans tend to believe both in their national security and their individual security, but also civil liberties. I think that's a tension that we've long tried to maintain. So we'll be talking about transparency today. Let me briefly introduce our guests, and you'll hear from them, and briefly each individual, then we'll have a brief conversation up here, and then we'll have a conversation that's open to you. Remember, the format here is that you fill out a card with a question, and those will get passed up here. I can't tell if there are 40 people out there or 600. But in any event, that's the way we'll do that. And so please, don't wait till the end of the session. If you have a question, write it down, and it'll get passed up here. Let me introduce Charles McCullough. Mr. McCullough is the Inspector General of the U.S. Intelligence Community as part of the Office of the Director of National Intelligence. Next to him, David Medine, Chairman of the Privacy and Civil Liberties Oversight Board. I don't think I need to repeat that I'm so pleased that each of these folks took time to be here. I'm perhaps more pleased in Mr. Medine's appearance that there is a Privacy and Civil Liberties Oversight Board that we could have asked to appear on this panel, because I have always believed that that has been an important missing link in the oversight process. So Michael Woods, over there on the end, is Vice President, Associate General Counsel for National Security at Verizon Communications, formerly with the Justice Department and the FBI. And our last guest is someone, and I have to say, well known to people of my age, because I think there are an awful lot of people, Marvin, who grew up watching you and your colleagues at network outposts around the world, and who I think really discovered an interest in the world and international affairs through you and people like you. And it's always a pleasure to see you and have you here.
Thank you, Bill.
So we're going to open with Mr. McCullough, and please.
Well, Bill, I want to thank you for chairing this important session, and I want to thank Chuck Alsop in particular for including an IG perspective in something as important in transparency. Might not be a surprise to you that as an IG, you don't get invited to very many things. So this is a little unique today. I actually feel a very warm sense that I may be among friends here, and that's an anomalous feeling for me as the intelligence community IG, and so I'm glad to be here and glad to meet with you. As I said, I am the Inspector General for the entire intelligence community. The President appointed me to the position back in August 2010. I was confirmed by the Senate a few months later in November of 2011, I'm sorry. And so I'm happy to be here representing all 17 of the Inspectors General who lead IG's offices within the intelligence community. All are members of something we call the Intelligence Community Inspector General Forum, which is a consortium of IGs and oversight people, and we gather on a quarterly basis to share best practices and to conduct joint reviews. So I am here today representing not just the ODNI, but the forum itself and all 17 of my inspectors general colleagues. IGs have always been advocates for transparency. Historically, the record is very clear that IGs have advocated strongly for greater transparency in government. We report to the executive, we report to Congress, but ultimately we work for the American taxpayer. Our goal is to make the IC more effective and more efficient by shining light on IC programs and IC initiatives through our many audits, inspections, investigations, reviews, and assessments. We do certainly recognize that full transparency of all information to all people at all times is impossible when you're talking about the intelligence community. I believe very firmly with this audience today, I'm preaching to the choir, and that you know that the national security implications of that make it impossible for us to do that. However, as a community within a community, the IG community within the Intel community, there are a lot of things we do, and we really have striven to do our part in furtherance of openness. We publish semi-annual reports to Congress. We publish the reports that we can publicly release that are unclassified. We do have reports that are too classified to release publicly, and we take great pains in many circumstances to formulate some unclassified format so that we can at least release the essence of the report in some unclassified, redacted, summary manner. An example of that is the report we just released a couple of months ago was the review of the information sharing leading up to the Boston Marathon bombings that my office led, and we coordinated and performed that review with the Department of Justice IG, the DHS IG, and the CIA IG. And while that report itself was highly classified and not releasable, we were able to take great pains to release an unclassified summary, and we felt very strongly that we needed to do that. So we also advocate for transparency by assisting and protecting the intelligence community whistleblowers who report violations of alleged misconduct and mismanagement. The President, the DNI, and the Congress have been very strong champions of our role in this regard. They've sponsored such authorities as the Intelligence Community Whistleblower Protection Act, and more recently, the Presidential Policy Directive 19, which provides specific protections against retaliation or reprisal for people who blow the whistle in certain circumstances. Our duty is to assist and protect these whistleblowers so that these allegations of wrongdoing can be properly investigated and handled. That is a duty to an inspector general that is of paramount importance to me and to the 17 IGs on the committee that I chair. There is nothing more important. As a matter of fact, I would go so far as to say it is our raison d'etre. It is our reason for being. We need the whistleblowers, and without the whistleblowers, we wouldn't have people making allegations and complaints for us to investigate, audit, inspect. So that said, all of the IGs in the intelligence community recognize there is a stark difference between what we in the community call whistleblowing, which we term to be the lawful disclosure of information, an alleged violation of a rule or a regulation through proper lawful channels. In contrast to and as opposed to what I would term and what the IGs in my community would term leaking, which is the disclosure of classified information outside lawful channels. My office and all of the IGs in federal government can protect people from the former, from retaliation for doing the former. If you've got a protected disclosure, we can protect you from reprisal for disclosing that information, whether it be to Congress, whether it be to somebody in an IG's office. If you're leaking and you're disclosing classified information in an unlawful manner, there is absolutely no protection for you. You're making a decision to do that outside of the normal parameters of the legal authorities which exist to protect you. So again, thank you for inviting me here today to represent the oversight viewpoint on transparency, at least from an IG perspective. I really look forward to discussing these points today here with you all, and I look forward to your questions for me.
Very good. Thank you. Mr. McCullough, let me just do one follow-up question, because this has certainly been out in the public conversation over the last year. And I don't know what the percentage of this audience, but I would say half at least are contractor personnel who have clearances with the intelligence community. Do they obtain protection as whistleblowers if it comes to that?
Under PPD 19, contractor personnel are protected if the retaliation from their protected disclosure comes in the form of an adverse action against their security clearance.
I see.
So as the directive is written right now, we don't have the lawful jurisdiction, or there's no actionable means for us to actually provide a remedy if there's an employment, an adverse action against their employment. You have a private company, you have the government. Now, you do have that outside the intelligence community. There are laws that permit that.
Okay.
We don't have that yet. We are working toward that. But right now, part of PPD 19 covering contractors, if the adverse action involves the clearance being affected negatively, that's appealable to an IG locally within the elements, or to my office, the ICIG.
Very good. Thank you. Mr. Medine, it was a long time waiting for the board to be reconstituted, but if you would, go ahead and give us your view on this.
Great. Thank you, Bill, and thank you to the host of this program. I'm actually quite jealous. That your nomination went through the Senate in a couple of months. It took 510 days for the Senate to confirm me. But they happened to, maybe they had some wisdom because they put me in place 4 days before the Snowden leaks. So I also should start with a disclaimer, which is that anything I say is are my own views and don't necessarily represent the views of the board or my fellow board members. Having said that, the board is very committed to transparency. From the beginning, we thought that was a really important part of the intelligence program to really gain credibility as part of the democratic process among consumers in this country and individuals around the world. Since we were constituted or reconstituted, we've issued 2 reports, and we started each report with the view that it might be partly classified and partly unclassified, with the classified version going to the president and Congress. But we thought it was important to be as unclassified and available to the public as possible. So in our first report, there had been so much leaked about the program and declassified, this is the 215 telephony metadata program, that it really wasn't much of a problem to generate an unclassified report. However, when we turned to the 702 program, we discovered that significant parts of the program remained classified. But we worked with the intelligence community because we felt that there were certain aspects of the program's operations that could be declassified. And in a very cooperative effort, we were able to declassify 100 facts about the program, which permitted us to make an entirely public report about that program, which I think, again, some have said maybe the most thorough examination of an ongoing intelligence program anywhere. And one of the important parts of our reports has been a section of the report just describing how the program operates, because there's been so much misinformation about these programs and misunderstanding that we felt, if nothing else, aside from our legal analysis and our policy recommendations, it was important that people understand how these programs operated. But aside from the transparency of describing how the programs operated, our reports themselves have contained some recommendations to enhance transparency. And a couple of those relate to the operations of the Foreign Intelligence Surveillance Court, sometimes known as the secret court. We like to see it be less secret. And so we've recommended that the court, on a going forward basis, draft its opinions with the view that parts of them can be declassified. And I want to sort of reiterate the point that national security is an important value, and the board has recognized that there are some things that can't be made public that harm national security, and we fully recognize that. But in the context of court decisions, we feel that the legal analysis can be declassified even if some details about operations shouldn't be released. And the same is true with, this would apply to court decisions that involve novel legal or factual or technological issues, certainly where the court authorizes a new or existing program. And the same would be true going backwards for court decisions in the past, but we recognize that's a greater challenge there because the judges weren't writing their decisions with the view that they might be declassified, and so that's a more challenging process. But again, if there are significant decisions, we think it would be valuable to have those declassified as well. The board has also recommended in the context of the court to have a special advocate, someone who can come in and argue against the government where appropriate, challenging the legal basis for the government's requests or the constitutional basis. And to make sure that that process works properly, again, in the interest of transparency, we've urged that there be some disclosure about how many times the courts bring in the special advocates so people understand whether it's a regular basis or infrequent. In addition to that, a lot of concerns have been raised by industry about government requests and their ability to disclose how much information the government's seeking, I think largely with the view that people have assumed the worst, and there actually less information is being sought than people have suspected, particularly from the early leaks. And our board has recommended, consistent with national security, that companies have a greater ability to disclose government requests for information. Since then, there's been an agreement with the Department of Justice and a number of companies that seems to be working well, allowing the companies to disclose in bands of numbers after a certain period of time, the number of government requests. And likewise, the flip side of that is to have the government disclose how many requests it's making, again, so people can put in perspective how often these types of requests are being made. In our most recent report, we also addressed the concern that how many US persons, how many Americans information is being collected, and there's a lot of uncertainty about that. But we went through a process of trying to figure out when the government can identify Americans, and we recognize that sometimes trying to identify an American actually raises more privacy issues than it solves. But there are instances, and we were able to identify about 5 or 6 where we think the government can confidently identify an American without adding to privacy concerns. And so again, for greater transparency of how many Americans information is being collected, we've also recommended the government be more transparent about that as well. So on a going forward basis, again, our goal is to try to enhance public understanding of these programs and encourage democratic debate about them. Obviously, our larger mission is to evaluate the balance between privacy and civil liberties and national security, and we will continue to do that both in how we oversee programs. And we also have another function, which is to provide advice to the intelligence community to help them as they develop new programs, new laws, new regulations, to try to strike that balance in the design stage rather than having to retrofit existing programs. And we've already begun successfully doing that. It's not something that will be in the news, but we think that that's a very important investment of time and effort for the board to work the IC and help them address these concerns as they're committed to do it early on. So thank you.
Thank you. My question touches on your last point, and that is, you're in a position to provide advice to the intelligence community. Are you in a position to provide advice to the FISA court?
We're not really authorized to be litigators, and so I think that's really in the realm of the Department of Justice. Okay. We also want to be independent of all of that and value that in terms of providing both advice and oversight. We're a little bit concerned that if we were to advise about a program and then the matter gets into the court, it puts us in a bit of a conflicting situation. So our preference would be just to provide the advice directly to the IC.
Okay. The specific instance I'm thinking of is there is proposed legislation in the House and in the Senate that, from an outsider's perspective, would seemingly add significantly to the court's burden and its administrative burden. Would you have any involvement in helping the Justice Department figure out how to implement something of that sort?
Well, again, they're following up on our recommendation that a special advocate be appointed, not in every case. And the run-of-the-mill Title I case where a judge issues an order is very similar to the search warrants that district judges issue around the country every day without having an opposition. But when they're creating a new program and asking the court to approve it, like a 215 program or a 702, we believe it's important to have an added voice in there. Some of the legislation that's pending in Congress now, the USA Freedom Act, would have the court consult with our board in the appointment of those special advocates.
Very good. Okay. Just as a reminder before we move on to Mr. Woods, if you have questions, please start submitting them and then they'll be collected. I have one personal plea. Please write legibly. I might add a second plea of attaching an honorarium for the moderator, but we'll skip that. Dollars would be fine. Pound notes would be fine unless you're from Scotland, okay? Yeah, ooh, that's groaning, I think. All right, Mr. Woods.
Right. Well, first of all, thank you, as everyone else has said, for inviting me on this panel. I am the senior lawyer and policy person handling national security matters at Verizon, and I suspect, although I'm speaking for industry in general, the reason I was invited is this experience of radical transparency that I had last summer on June 5th. I got a call from a press officer in our company who said, there's a reporter asking about a document, and I don't know what it is. I said, well, can you read it to me? So he has the reporter on one phone, and then he's picking up the other phone to read to me. And about 20 seconds into it, I realized this is a document classified TSSCI. It's a secondary order of the Foreign Intelligence Surveillance Court relating to bulk collection. And he said, well, what should I say to the reporter? And I said, well, you should say no comment, and you should get off the phone. So as a private company, particularly a communications company, in the discussion we're going to have here, we kind of occupy the ground in the middle. We are, in the modern information architecture, I think the collection of intelligence will very often, if not almost always, involve the cooperation of industry, particularly communications and technology industries. And that raises the question for the industry as what can we say about that? And our perspective on it is a little different, I think. That for us, our notion of privacy, our interest in transparency starts with our customers. There's sort of a general industry standard about privacy, not necessarily all the aspects of it, but how we present it. So most of our companies, tell our customers, this is the information that we have of yours, these are the business uses that we make of it, and these are the circumstances under which we turn it over to governments. And I say governments because, and it's another wrinkle in this whole discussion, most of the large technology companies and most of the large communications companies operate in an international environment. Verizon operates in over 100 countries. And so for us, it's not just a matter of working out this issue with the United States government. It's an issue of working it out with quite a large range of governments around the world. And that has become increasingly important in this debate. It's also, by the way, important in the internal governance of corporations. Our executive structure has many people in it that are foreign nationals. Our company is not as global as some, but more global than most. And it raises, for any of you who are interested in corporate governance, raises internal issues of how does a company decide how it's going to handle these activities? How does a company decide how it responds to government requests? When does it challenge something? When does it push back? And most importantly, what can we tell our customers? What can our privacy promises to them be? So our interest in transparency has developed, I would say substantially over this past year. I think we were the first major telecommunications company to put out a privacy report, a transparency report. We did that before the Justice Department promulgated the rules for it, so it was fairly minimal. And the rules in place now allow us to report, and they're somewhat restrictive. this reporting in bands and the delayed reporting and the certain non-reporting of new technologies and things like that is all set out in a series of rules that's kind of become the standard in the industry. But we have, as an industry, sort of pushed for that transparency because it allows our consumers to get some sense of the magnitude of information that might be compelled to be produced to the government, and a little sense of how that is done, although very little for obvious reasons. And we're engaged in a very active debate, as are other communications companies and tech companies, about how best to do that and how far that can be expanded. And, you know, as a private industry, as members of private industry, there is a business aspect to this too. Many of us have taken a beating overseas after the Snowden affair, that this is being used competitively in other countries. It's having effects on the structure and development of the internet. We see, you know, impulses toward the balkanization of the internet, which would have profound implications technologically and economically. So for us, transparency becomes an issue of, and you know, I don't think many companies have illusions here that we can convince the rest of the world that there's nothing to worry about here, that you can trust these institutions. As fine as the institutions are, you know, people outside the United States have a different perspective on this. And they are, yes, I know, it was shocking, but they, you know, it will take much more than reports and even statutory changes, I think, for people to have confidence. I'm not sure that I don't know how realistic a goal that is. On the other hand, I think that one of the reasons that we are experiencing this overseas is that compared to most of the world, we already have a pretty transparent system of intelligence law. We're one of the few countries where you can read in detail things like the Foreign Intelligence Surveillance Act. So there's a very rich discussion, I think, to carry on here. But those are the interests that you know, to come to the forefront of, you know, my mind as a representative of Verizon, and I think common across the industry. There's some differences in the industry on how transparency should be accomplished. Our view is that it should be accomplished primarily through government reporting, because we think that, particularly in the communications industry, the complexity of government requests and the many different varieties of information and methods of collection make it very hard for you to get an apples-to-apples comparison if you're just letting companies report on their own. We'd much rather see the government report in a standard, unified way that is, in fact, the way the government seems to be moving. So there are others in the industry, in the other industries, that say they would prefer more discretion on the part of the companies, that the companies would be able to report in more detail what they received or did not receive from the government. So there are probably a wide variety of motivations depending on what it is that you're not being transparent about. It might be the fact that you've never received a request. It might be the fact that you receive thousands of requests. But there is certainly a general push towards transparency in the industry. I'd be sort of happy to discuss that further.
You've touched on a really important issue. I was talking to my students this morning about the fact that within 4 or 5 years after Sputnik, we had an international treaty governing the peaceful use of space. And that we're 30 or 40 years into the internet revolution, and we're nowhere close to something like that because the number of actors is so exponentially greater. Do you have any thoughts from Verizon's point of view about will this settle down into a more regular international environment?
Well, we have lots of international agreements on how the internet's run, but they're technical, right? They're on how you assign domain names and how you interconnect systems, et cetera. I think the problem with them is that with respect to intelligence, like a number of international treaties, this is sort of politely ignored as something that everybody probably does. No one really wants to talk about in the open, and so we're not going to have an international agreement on what it means to collect intelligence. I think it's a very tough pull, but on the other hand, when I look at the information architecture, it's very hard. I mean, I tell people that geography is becoming irrelevant It's very hard to assign a nationality to a digital identity. Very, very hard. And U.S. intelligence law and regulation is premised on being able to tell U.S. persons from non-U.S. persons, U.S. person data from non-U.S. person data. If that distinction becomes harder and harder to make, then at some point we're going to be faced with the need of defining a broader standard. I just don't know how we get from here to there. I think we're quite a ways.
Mr. Kalb.
Are you sure you want me to speak?
Absolutely.
I've listened now to my three colleagues, and I have learned a great deal, and I am honored to be on the panel, truly. But I'm almost certain in my gut that I'm the wrong person here. Because when I listen to a lot of the language that is being used, and I know it's articulated with the best will and intention in the world, it can be read, forgive me, but in a different way. For example, leaks, which you mentioned a moment ago. I don't remember the exact words that you used, but you used the word unlawful in describing it. But what happens when the President of the United States calls in the New York Times reporter and gives him information on a background basis with the understanding that the Times is going to run it, else he would not have invited the reporter in? And it is reported on the front page of the New York Times the following day. Was the president involved in an illegal action? And I would argue that the idea of leaks is a fundamental way in which government deals with the public by way of the media. Leaking information sounds awful, but it is common, it is ordinary, it is routine, it happens all the time, from the president right on down to a deputy assistant secretary of state. Everybody is leaking information. Why do I say that, sir? Because you are vastly what's that word?
Overclassifying? Classifying?
Classifying information. You're vastly overclassifying information, with the net effect that the normal stuff that goes from the government to the public by way of the media is ordinary, and you're stamping it secret and top secret and all of that. I remember many, many years ago when I was a young person at the American Embassy in Moscow in 1956, and I was looking at top secret information for the first time in my life. I was terrified simply to pick up the piece of paper. But one of the things I picked up, literally, this is the case, was an article in the New York Times that was clipped out, put on a piece of paper, and stamped top secret. So I had read that in the newspapers. So I asked the ambassador, who's a wonderful man, sir, explain this to me. Why is this top secret? And with a straight face, he said, because if anybody knew that we were interested in this here at the embassy, it would be connected to other things. And I didn't quite understand what he was getting at, but I didn't understand it then, and truly I don't now. But so there's this overclassification. Another thing, people in this government, and not just in this administration, but going back as long as I can remember, and that takes us to the Jefferson administration. But most people do not understand the ground rules for disseminating information to the public. There is on the record, which most people seem to think they know, and then there's off the record. Off the record is not what most people think it is. Off the record could be literally, don't touch this, or touch it, but don't use my name. And that is routine. That happens all the time. If you go to a Senate hearing, and you happen to be lucky enough to be one of those permitted in to listen to it, it's on the record, and a senator will ask a question. This is literally the case quite often. A senator asks a question. Another senator says, or the chair says, I can deal with that question. later, but in closed session. So as a smart reporter, you sort of hang around. So they go into closed session, and then the senators come out, and you happen to know one. So you walk over and say, Senator, what's going on that thing? Curious. And he'll say, well, don't quote me, but here it is. Following day, I put that on the news at night. The following day, I got a call from his office, from his spokesperson, who said the senator was extremely disappointed in you. Why is that? You didn't mention his name. I truly don't mean that there's anything terribly funny about this, but we're living in a world right now in which change is so rapid, it is so expectable and instantaneous, and we are dealing with rules and understandings and definitions that are antiquated, that are not up to speed with where we are today in terms of the flow of information, the effort to be transparent, the effort for a corporation in high tech to produce information for the government to use, but in what way, as you were saying before. It's a very interesting question as to who distributes this information. Should it be the government? Or why can't a reporter turn to Verizon and say, Mr. Verizon, you did it, so you know what's going on. So do you mind telling the public what's going on? And there is a feeling, we're all, I think, oppressed by concepts that are currently outdated. I think we may be getting to a point where we may have to think almost in un-American ways about holding on to information. If information is truly important, significant to the national interest, then the person in the government who has that information should not be talking to the reporter, period. I can tell you right now that when the Snowden stuff began to come out, I was appalled by it. I thought that what Snowden did was utterly reprehensible. If somebody works for the US government and has that information at his or her disposal, it is that person's responsibility to keep it secret. If that person chooses on his own to release that information, he then is responsible for the consequences as well. And I think that there is something that we might engage in a conversation here about what is today news. How do you deal with news? I am, as a former journalist, I've been teaching for a while, but as a former journalist, I can tell you that I sometimes don't recognize what today is described as journalism. I don't recognize it. I'm not sure that many of the people who you all listen and watch in the evening on cable are journalists, and yet they act as journalists on the air. And somehow or another, journalism still retains enough of a legitimacy and a respectability that people hide behind the word in order somehow or another to come through as more honest and straightforward and all of that. But I don't recognize some of these people. I don't recognize my profession quite often. And every now and then, I'm not even sure I recognize what my own government is attempting to do. And I think the reason for that, and forgive me if I'm repeating myself here, I think the reason is that the technology has advanced so rapidly that the government has to keep up with it and may not be able to keep up with the rush of the technology. And if the technology is ahead of the individual's capacity to manage the information, how then do you deal with governance? I'm at the Kennedy School, and I can tell you we deal with this issue every day. How do we define governance? What is it that is right, proper, and up to speed about the US government, and what isn't? I think I better, that's enough.
And let me pick up on that, because I think that's an important point about the speed at which this information environment has moved. And you compare that speed to how legal structures improve and bureaucracies improve. I can remember early in my career at NSA carrying boxes of IBM punch cards around the halls. I showed them to my students last week, and they were like, what the heck are those? And so as long as you have a technology that moves that fast, and I think you can see it even in the housing crisis, the financial crisis of 6 years ago, the regulators did not have the ability to keep up with the information that the industry had. And I think that's a very dangerous sort of thing. But let's talk on one specific thing here, and that is, how does government, in this case the intelligence community, deal with what we've known for 40 years is a problem, and that is overclassification. Too much stuff is classified, and it's held too long. There's a story about Governor Kane when he became co-chair of the 9/11 Commission. He was the last member of the commission to get his clearance, and he was brought in, and read folders were accumulating. And he's flipping through these read folders, and there's a minder in the room to make sure he doesn't stuff them in his pants or something. And Governor Kane looks up and says, but I knew all this. Mm-hmm. And the minder says, but Governor, now you know it's right. You know, and there is this sort of hubris that kicks in with, you've got something classified. And this has been identified by everybody. There's the Information Security Oversight Office. Does an issue of how we deal with too much classification, does a solution to that or a partial solution, does that help with the transparency problem? Anybody want to speak to that?
I would reject absolutely the premise that there's too much overclassification. And I don't know, other than what you provided or what we provided anecdotally, whether you have any evidence of that. The entire IG community, not just the ICIG community, the entire IG community, those that had people who have security clearances, just did a year-long review, in some cases 2 years long, with respect to this particular issue. And a lot of these reports have been released publicly. They certainly are FOIAble. Congress certainly has them. And I don't think what you're going to find if you look at those reports as a whole is that the IGs found there was a rampant overclassification problem, systemic all the time. Mm-hmm. Are there problems here and there? Is there a problem with training on classification? I know that my office is completing its own overclassification review, and we're actually collating the reviews for the rest of the community and synthesizing, looking at the trends to determine whether or not there are specific issues. There's one issue with the Hill. Are we using Orcon? That's the particular sort of bugaboo with the Hill. They're very convinced that Orcon's being misused. And so that's not something that really we looked at empirically, and we haven't found the evidence to support that argument. So if you have some specific evidence other than just sort of anecdotal evidence of a person here or there whom you know overclassified something one time, when you actually sit down and get the documents out, look at the classifications, go to the Orcon, go to the original classifier, I would reject the premise that we actually have an overclassification problem.
And let me be clear about something. I'm not sure there's overclassification at the instant of classification, but it is more a case of stuff being held for such a period of time that you wonder why.
So you're talking about the third-party rule. This is the Orcon.
No, I'm talking about the fact that you have 30 and 40-year-old documents that you wonder, in 1967, there may have been a valid reason. And that's what, so right. You may be correct that it was validly classified. Why is it still classified?
And then with respect to the comment on Snowden, there were a lot of comments I'd like to respond to, but I just, that was the one. So as I said, there were 17 IGs. All of these IGs were ready, willing, and able to accept those complaints from Mr. Snowden. All of those IGs, and some of them employ PhDs who are well-versed in 12333, UCIT 18, 5240.1-R, all of the relevant authorities. They do this for a living. And we never got that opportunity. Mr. Snowden decided to take those classified documents to the media. And therefore, we can offer him absolutely no protection whatsoever. So if the word leaking offends, that's what it is. If, again, in the intelligence community, We work with whistleblowers every day. If the whistleblowers aren't following, Congress has passed very set sort of legislative schemes. The Intelligence Community Whistleblower Protection Act, there is no reason a person who wants to make a complaint to either the Senate or the House Intel Committee can't have that complaint communicated to the committee, and they can do it themselves. We will facilitate that. That's our job. And we go around the community, we go around the contractor community doing outreach programs to educate people about how to do that. So that is something that may be a more recent development, but anyway, so.
I would just add that the federal law also protects whistleblowers who come to the Privacy and Civil Liberties Oversight Board. And so, again, we were only constituted about 1.5 years ago, but if there are individuals who have concerns about how programs are operating that raise those issues, they can come to PCLOB and get whistleblower protection.
And I would say about whistleblowers, people get this misconception that if you're a whistleblower, all of a sudden we give you this magic cape, and you've blown the whistle, and now nothing can do anyone to harm you. And whistleblower reprisal is more about the remedy if something bad does happen to you because of your protected disclosure that you've made to a proper party through proper channels. The laws and the authorities which are currently written allow the IGs to hold those people accountable, to hold the people who may be retaliating against the whistleblowers accountable.
I'd also just note recently Mr. Tai, who wrote an op-ed in the Washington Post, is an example of a whistleblower who did it the right way. And that is he wrote an article and he submitted it to the intelligence community for classification review, and they determined that he could publish it without any classification issues. He testified before our board and raised concerns, and again, consistent with classification rules, he's always free to come to us or to the IG, ICIG, or someone else, even as a former employee, and can come in and tell his story if he has concerns in a classified environment. So there are ways to do it consistent with law that still raise public concerns but doesn't compromise national security.
Mr. Kalb, you had something?
No, I decided not to.
Okay. If somebody has something, all right, let's tell you, I'll give you an opportunity for those of the panel before we go to the questions. Any last thoughts from you before we open to Q&A?
I just think on the issue of classification, it's not a corporate position, but I agree that there is an issue there, and one of the implications of it is that it undermines the credibility of the institutions that are supposed to give comfort in this. And the example I would give is an internet service provider, Yahoo, raised a very thorough challenge to the predecessor to the FISA Amendments Act, which is the beginning of the 702 program, in 2007, 2008. We found out about that in 2014. It's just been declassified as part of this, and it's very hard for me to understand why. I can understand specific details but this was an instance of an oversight mechanism working as it should have worked, of someone using that system as it should have been used, and it was invisible to the larger community. And this, the same has been repeated in other legal proceedings more recently. And we've learned more about the FISA court's operations and more about its vitality since Mr. Snowden than we learned in the 20-some years that preceded that. And if these documents were really that damaging to the national security, and these are legal arguments mostly, so I think there really is a question there that should be looked at.
I think there's certainly a question. I guess my point is, when you're dealing with classification issues, anyone in the intel community who works with these documents on a daily basis is going to tell you that classification is not an exact science. And there are plenty of situations where a document or set of documents which may appear in a vacuum, wholly unclassified, maybe FOUO, placed with other documents which have already been released. We have this montage theory where all of a sudden all of these documents now become confidential, secret, no foreign classified documents. So I agree, this is not an easy issue to deal with. This is not an exact science for the people who are the original classifiers of documents.
Let me take part of that discussion to go to the first question that we have, and I will paraphrase them so you may not recognize your question. but this is what I'm drawing from. The public, among other things, I think has learned a lot about the FISA court that they didn't know before. And I guess that raises the question of whether the executive branch, including the intelligence community, should have done more to reveal some aspects of what Mr. Snowden revealed in a way that they could have controlled it. And I'll open that to anybody who wants to deal with it.
Well,
Sure. Go ahead.
I mean, I think we've learned a lesson over the past year and a half that having it come out in the fashion that it did undermines public confidence in these programs, and having a democratic debate about these programs while still preserving national security is beneficial. I mean, one example is a contrast between at least the legislative authorization for the 215 program, where nobody could really tell from reading the statute what it was authorizing, versus the 702 program, where at least those who were involved in the debate who won or lost the battle over what it is in 702, I think pretty much everyone says, yeah, we got exactly what we expected to get. And I think that greater transparency builds confidence. I think the Foreign Intelligence Surveillance Court has gotten a bad rap. And they are much more rigorous than it's been reported. The notion that the government wins 90% of the cases doesn't take into account the fact that there's a lot of interactions with the court and the court staff to refine requests, sometimes even to encourage the government to drop requests that they know are not going to be approved by the court. So I think certainly, I don't think if anyone could do it over again, I think they'd certainly rather have had more transparency.
I've actually thought at times if that 99% were correct, then my experience as an analyst at NSA would be that I was responsible for all of the 1%.
Right.
Because that 99% does not count the ones that came back to us with questions from the court where we decided we're not going to go forward.
Exactly.
And so that's very good. Any other comment on that question? This is
You want to go?
I'm sorry, Michael, go ahead.
Well, I have to take off my corporation hat because I'm a longtime FISA geek. But I think that, if you look at the development of the Foreign Intelligence Surveillance Act in 1978, a whole reform period in the intelligence community that was actually sparked by other disclosures. I mean, that seems to be how we reform things in this area of the law.
That was the Church Committee.
Right.
Mid-70s.
And the Seymour Hersh. And
Yes, indeed. Yes.
I think
those are reporters, by the way. No, seriously, those are reporters, and those are senators with huge integrity and prepared to lay their political lives on the line in order to do something which they regard as important to the integrity and the security of this country.
Okay.
It was, I used to entertain audiences at the FBI Academy when I would teach there, about how detailed and bipartisan that effort was. And few of them knew the two co-sponsors of the Foreign Intelligence Surveillance Act were Ted Kennedy and Strom Thurmond.
Yeah.
A political matchup that you could hardly imagine in any context today. But I think if you look at the way the statute's structured, those people really envisioned a more open court functioning than we ended up having. I think they thought that there was going to be a body of law that would shape this, that would be more accessible, at least the legal reasoning of it. And in fact, that didn't happen, and we ended up with something very different. So I think that some of the developments are quite welcome in terms of the visibility that we have into the legal reasoning of this court. It's the one court that's really thought about these questions in a concentrated way, and now we know at least a little bit of what they think, which is a good thing in law.
Mr. Woods, I'm going to keep on a corporate track here for a second, and that goes to this whole sequence of the last year and a half or so in particular about disclosures. What has this period done to industry's willingness to trust government, to work with government, to meet future national security challenges?
I think it's certainly in the parts of the industries that I'm directly familiar with, it has really undermined confidence in the government, even where there have been long relationships. I think that it raises questions of what is and is not in the open, and how will one of the questions it certainly raises is, can the government protect the fact that I have been in this compelled relationship through an order, Or do I need to treat that as a public fact? And if I need to treat it as a public fact, and I need to treat it public in the international environment, then what does that mean? I mean, it has kind of changed that debate. But I don't want to put too much emphasis on that, because I think that if you go back in the intelligence community, people thought traditionally of companies as American, right? So AT&T, Verizon, big phone companies, these are American companies, and they should jump in with our national security, and that's increasingly not. I mean, it's not that American companies aren't concerned with the national security. It's that these companies are transitioning into global companies, and they can't behave as if the U.S. government is the only government. We have the Europeans who have very different approaches to this, and they have authority over us when we operate there. And so it's a very complicated thing for companies to figure out, and I think that was a process that was developing. I think it's just been accelerated by the events of this year. It's been brought into clearer focus.
Okay. Any other comments?
And Bill, that very much has to do with the power of the new technology to begin to determine things that we're uncomfortable yielding authority to a technology. You want to feel that a human mind is in charge of governance, right? But are we absolutely sure that in 5 years from now, the people running the government will be up to speed with the technologies that are being developed, not just at Verizon in this country, but all over the world, under a Verizon umbrella or under foreign umbrellas? And then who's supposed to be responsible for that? Is the responsibility there just for the American government or for a particular corporation? What is the role of a journalist in this? If a journalist comes up with information, you have to ask yourself, if it really challenges the issue of national security, editors are prepared to listen and have listened to the government time and time again, and most of the time yield to the government. Most of the time. You turn to a guy like Ben Bradley, who ran the Washington Post for many years, and you ask him now, how many times, Ben, did the government come to you and ask you not to run a story? And he would say, a couple of times a day sometimes. What did you then do? I didn't run the story. In other words, if there's a doubt, you don't go with it. With national security is terminology that not just government people are smart enough to understand, reporters understand it too. And a reporter can come upon information that in his gut and in his head knows that if broadcast is going to produce negative consequences for the United States. What then do you do about it? Now, I was mentioning before that there are many times small stuff, big stuff. 6 Americans are at the Canadian ambassador's residence in 1979 in Tehran. I learn about that at the State Department. How do I learn about it? Is it somebody taking out a piece of paper and saying, here's a leak, Marvin? No. It's that you talk to people, and you know, Dean Rusk used to say that we know, the reporter knows 95%. It's the 5% that he doesn't know. But in that 95%, there's information, and you pick up a little something or other, and it suddenly makes sense. They're at the Canadians. What did I do at that time? I didn't broadcast it. Why? Because I don't want to hurt 6 people. Or the time that a young lieutenant will tell me in Vietnam that he's going off to bomb Hanoi, and we weren't yet bombing Hanoi. That was a big news story. So what did I do? But I'm putting myself up because I know what I did. I don't know what others did. I'm sure it's fairly widespread. I said to the young man, you shouldn't be telling me this, really. Mm-hmm. And why did he say it? He had seen me on television and wanted to sort of be with a guy who's been on television. So he felt good about sharing that information. Should he have done that? No. Did he do anything that horrific? He might have. If that story had gone out, the North Vietnamese would have known about it. They could have shot at the plane and killed him. Why do we do some of these things? There are good reasons and bad reasons, but we are at a time, this is really, for me, a terribly important point. Are we capable of managing the technology today? And if we aren't, acknowledge it and let's try to deal with that problem. If we are, fine, but I think the question ought to be raised and discussed.
No, and I think that's an important issue because if in the period you're talking about, even the hostages in Iran, the number of media outlets were far fewer. The number of you talked about the change in your profession. Someone had to tell you about the hostages or other things, or the pilot. But nowadays, if you've got a private Manning who hits send and sends a whole bunch of stuff out to 5,006 or 5,000,006 people less responsible than CBS or the Washington Post in those days, we do have a problem of managing the technology.
Exactly.
I don't know what the answer is to that. Let me ask a question. This is, I think, an interesting. You know, the intelligence community in trying to deal with the Snowden disclosures and the insider threat is going to this process of long-term or continuous evaluation. Now, this is a change in how we clear people. Hey, it's 5 years, you're going to get re-upped versus continuous evaluation. And this question is, are plans in works for developing privacy standards for the collection of publicly available electronic information to support continuous evaluation? I hadn't even thought of that, but either of you have any thoughts on that?
We haven't looked into that.
I think that's probably addressed to the Office of the National Counterintelligence Executive more appropriately. So
good. All right. I think that's a question maybe at future occasions we can deal with. Does the Open Government Directive implemented by the Obama administration apply to the intelligence community?
which directive?
The Open Government Directive that's from the administration. I'm not that familiar with it, but okay.
I doubt it.
Try again.
Let me go through a couple more of these. If I can recall this one, but I thought this was kind of interesting.
You got some others there.
Yeah.
Oh gosh, we're not going to get there. All right, all right, here's what it is. If social media can adjust to the publication of nude photos of Hollywood celebrities, could the public react to the disclosures of national security information, a sort of public campaign of revulsion? What do you think? Maybe it's good I didn't find that card. Okay, yeah. All right, we'll pass. I should have let that one go. Oh, a serious issue, Marvin, first for you. Any comment on journalists apparently becoming targets of choice for ISIS?
Targets?
Of choice for ISIS.
It's a terrifying thought. Years ago, as a reporter covering a war, I always felt that if a bullet came at me, it would then go around me because it would understand that I was just a reporter and that I'm not part of this war that you guys are having. But that's not true any longer. And it's not true because the reporter has become too central a player in decision-making, in influencing our political system, in determining what it is that presidents do and don't do. I think the form in which journalism exists today is too powerful. Now, what you do about that, I don't know. And I am also, at the same time, frightened by governments that are on the edge of putting a New York Times reporter into prison for having talked to somebody who was in the government, who had a top secret clearance and gave the reporter information. The reporter didn't have a top secret clearance. You're going to put the reporter in prison for that? We've been talking here a lot, and just one final point from me, and I'll shut up, though. We talk about how the public knows something. How does the public know something? All of you in this room, how do you pick up your information? What do you do? When you get up in the morning, do you turn on NPR? Do you just turn on your set and listen to what Yahoo has to say? We are being soundbited to death, and we seem to enjoy the process. How do you get the information? Where does the information come from? Are you certain there's any validity to this information? Do people ask these questions of themselves? There's some responsibility that goes along with being a free citizen in a free society. You want information? Fine. Find out whether the information that you're getting has validity, is accurate. That will help you understand the government, and I wish the government would do a good bit of that itself to understand the public. We are the middlemen, but I fear that increasingly we're too influential.
We are running out of time, and I will just give you a chance to comment on this one thought, and it is, the question is, how do you propose closing the gap between the intelligence community and the media with respect to classified information? And I would just add, before you start to answer, I think conversations like this are extremely healthy and extremely useful. But your thoughts. Is there a gap? How do we close it? What actions should we take moving forward?
You want?
Any of you.
Well, I start with one simple proposition, and that is that if you don't treat the media as an enemy, but as a potential resource, which it is, bring it into the beginning of your decision-making. You will find the media, 99.9% of them, will be responsible. For the 0.1 that is not, I don't know what you do with them. But don't put them into prison.
Okay. You gotta you personally get a get out of jail card. Okay, I'll give you that. Any other comments on that before we close up? Let me close by saying a few things. I have a couple of announcements here. But on a personal note, I entered the National Security Agency just about the time that we were going through Watergate and the post-Vietnam thing. I needed a job. When I got the job at NSA, one of the professors on my dissertation committee refused to speak to me and never spoke to me again. Huh. I got to NSA. That was actually a plus for me, I think. but when I got to NSA, we're in the whole turmoil, Pike and Church and all that sort of thing. And I remember people accosting me in the halls and saying, "It's time for you to find another job. We will not be able to function under this sort of scrutiny." The British don't deal with it. The French don't deal with it. The Israelis don't deal with it. And I was a bit frightened, but I didn't have another job offer. And I stayed in the intelligence business long enough to run congressional affairs for NSA. And I would say, and I say to my classes now, the creation of an oversight process for American intelligence is one of the great achievements of American intelligence. Whether it's the House and Senate Oversight Committee, and I know they're not perfect, but nevertheless, the FISA court, all these things that we thought would have terrible impacts. We can't do intelligence this way. Not only that, I've had the experience of briefing people from the UK and other countries that have set up oversight processes because the sense was we were the experienced folks on this. And having studied in British history as my field, and having spent time at Cambridge University and being shown my quarters in what is said in the most patronizing way, "Oh, this is the new building, 1605, as if to say, "Oh, you colonials have nothing of that sort." That having the opportunity to brief the British Parliamentary Oversight Committee when they were first created was such a pleasure. Such a pleasure. But I would say to this audience and to any other audience, and I would welcome doing this, we could take this on the road. I don't think there's any question that the statement Mike Hayden made some years ago, American intelligence can only survive with the support of the American public.
Absolutely.
And that is still true. And I think conversations of this sort are important. And I really want to congratulate INSA and AFCEA for putting together this forum where we can talk openly about things. Keep in mind, 15 years ago, you could be sent to jail in the UK for identifying the head of MI6. And we do have the most transparent intelligence service in the world. Finding that balance will be difficult every time the environment changes, the technology changes, and we're going through both right now. But as I tell my students, if you want to change the system under which we operated, particularly after 9/11, and that forced dramatic changes on all of us, there are 535 people down on the Hill that you should send your opinions to. Speaking of that, at 7:45 tomorrow, how's that, Maureen? I think that's Maureen. I can't tell who the hell that. You'll have a chance to hear to I think, one of the really significant figures in congressional oversight of the U.S. intelligence community, Chairman Mike Rogers and Ranking Minority Member Dutch Ruppersberger. So we have the networking reception down in the exhibit hall. We have an early start tomorrow, and then we'll reward you for that early start with a presentation by, I think, two really distinguished members of Congress. So with that, thank you all. Thank you.
I thought you were saying this. Oh, very good. Thank you.